Notaries minimize your liability. The importance of have E&O insurance and notary surety bond. Errors and omissions, E&O. Insurance protects the notary against unintentional mistakes or groundless allegations of impropriety. The notary surety bond is essential protection for the public against any misconduct by the notary. The likelihood that either will need to be drawn upon can be minimized by the notary's adherence to these generally accepted notarial best practices. E&O insurance is vital protection for the notary against unintentional mistakes or baseless allegations. Notarize only for signers who are present. Notary public who takes their responsibilities seriously will always ensure that a signer requesting a notarial act is present during the notarization process. No exceptions. A notary can significantly cut down on the risk of potential liability simply by adhering to this fundamental principle of the notarization process. It is more common for notaries to be taken to court and have their commissions revoked for failing to insist on a personal appearance than for any other type of misconduct. Don't notarize documents with blank spaces. Before a document is notarized, it should be complete in every way. A blank line in a document for an interest rate or loan amount invites fraud. By filling in the blank when you notarize, you will protect both the person signing and the transaction. This can keep you from having to go to court. Several states now have laws that make it illegal to notarize documents with blanks, so you should avoid doing this. Never pressure a person to sign. The act of signing a document in front of a notary public must be done voluntarily by the principal. If the signer was pressured or coerced into signing, whether by other people in the room or by the notary, this could result in the document and the transaction it was referencing being discredited or invalidated, which could lead to potential legal action. Because of this, before notarizing, you need to make sure that the signer intends to sign the document voluntarily and that the signer understands what they are signing. This will protect all parties to the document, including you, the notary, from claims that they were coerced into signing it. Know or identify your signer. The most important reasons to have a document notarized are to identify the signer in your presence positively and to administer oaths and affirmations to signers who swear or affirm that the statements in a document are factual. Most cases in which notaries are sued involve forged documents, which can be avoided if the notary carefully adheres to all applicable laws and best practices for identifying signers. Having personal knowledge of the signer, the sworn vouching of one or two credible identifying witnesses, or relying on a reliable and current identification document as prescribed by state law are typically how a notary may identify a signer in most states. In some states, the notary may also rely on the testimony of one or two credible identifying witnesses. Check the laws of your state to see if there are any specific identification requirements. Don't give advice. Be aware of your authority. Notaries can avoid liability in the event of claims or lawsuits. A notary commission does not confer your authority to provide legal advice, draft documents, or choose the document type or notarization for a client. Nor does it authorize the notary to perform notarizations. Not only can providing unauthorized legal services get you in trouble with your commissioning official, but it can also provide a basis for legal action if the legal advice you provide is incorrect. The signer suffers financial harm as a result of it. Don't give advice. Unless the notary is a licensed attorney or a professional who has been appropriately trained or certified in a particular field, the notary should never engage in activities that constitute law practice. Suppose the notary is a licensed attorney or a professional who has been appropriately trained or certified in a particular field. In that case, the notary should only practice law within the strict limits of the notary's field of training or certification. Keep a journal. Keeping a journal of every notarial act is critical to protect the notary from being sued. The journal can show that a notary took reasonable care when doing a notarial act and that, throughout many notarizations, the notary always followed the proper steps. Also, the journal entry can help the notary if they are ever asked to write a statement for an insurance company that is looking into a claim against the notary or testify in court about a notarial act that was done months or years ago. Without the journal entry about the notarization, the notary would have difficulty remembering anything vital about it. Requiring a document signer to leave a signature and even a thumbprint in the notary's journal can stop fraud in the making or stop signers with second thoughts about the transaction from going through with it. Thank you. Subscribe to the channel so that you don't miss anything.